Hello, everyone. Welcome to episode 48 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. I'm sorry that I'm inside today. There were a lot of lawnmowers and other noises out there that I thought would be too distracting. So I'm actually coming to you live in Le Chambre El Justin. And so that's all his awards and stuff back there. And he's going to college. So that's all kind of crazy. But anyway, hello to everyone who's here. And just really quickly, we'll do COVID first today, because all I have to tell you is that there are 206 more cases and 25 more deaths, bringing the numbers up to 58,241 cases and 5,595 deaths in Michigan. And the only other in regards to COVID is that the playgrounds in Oakland County opened today, so that's a pretty exciting thing. And so let's move on. So today is part 5 of our 5-part series about domestic violence. And just to review, if there's anyone new watching, episode 1 or part 1 was all about the different kinds of abuse that can constitute domestic violence or family violence, not just the kind with bruises and Band-Aids. But we talked about emotional abuse, we talked about financial abuse, we talked about social or isolation abuse. Episode 2, we talked about why, when the crime rate has dropped during COVID-19, domestic violence cases, if they have dropped in certain communities, have not dropped at as fast of a rate, or they have increased. In part 3, we talked about the different offenses that someone could be charged with if they were involved in a domestic assault, depending on the facts and circumstances and who the people are involved. That can make a difference as to what the charge would be. In part 4, which was yesterday, we continued to talk about those same a little bit more about the different offenses, more offenses. We talked about personal protection orders for like 30 seconds yesterday. And so today we're going to wrap up our series by what happens to me if I get arrested or charged or accused of domestic violence. As I mentioned before, there is policy in Michigan that if someone calls 911 with a domestic dispute, whether it's an argument with a lot of yelling, whether it's if it's between anyone in the household, the police will respond. They have to respond, and someone must be removed from the situation. In certain jurisdictions, there's discretion on if that person is actually arrested or if they're just removed to calm down. In others, someone is required to be arrested. And this is all funded through a grant to prevent domestic violence in Michigan. And so, those policies are followed, accordingly. And in some jurisdictions, they're prosecuted more vigorously than others. They're all prosecuted vigorously, just some it's more vigorously. And some of them, there are some other factors that can come into play that help us with resolution or mitigation of the case. The most important thing, first thing that I tell everyone, is if it's a dispute between a parent and a child, you need to immediately enroll voluntarily in parenting classes and therapy with your child. If it is between you and your spouse, you may want to consider going into therapy immediately with your spouse, or taking action to remove yourself from your relationship with your spouse or your girlfriend or boyfriend or loved one or relationship, baby daddy, baby mommy, whoever it is. But these are decisions that have to be made. As soon as someone is arrested or removed from the scene, they will be taken to the police station. At that point, they will be processed, and they may have to take a breathalyzer. It wouldn't be required, but certainly in the spirit of evidence gathering, the police might ask them to take a breathalyzer. You have a right not to take it, even if you're under arrest. Then what will happen is the person would either be released on bond. Usually it's just $100 if they're going to be released in 24 hours from the police station, or if it's a repeat offender, or if it's a circumstance where the person has nowhere else to go but home, then that person may be held in the county jail until they're arraigned in court. A person is supposed to be, in a perfect world, arraigned within 24 hours. Often it's a little bit longer. It could be a day longer, sometimes 2 days longer. And what happens at that hearing is that the magistrate or the judge will read the charges, whatever they are, and then will talk to the person accused, the defendant, and their attorney, if their attorney is present, and he'll be advised of it, or she will be advised of their rights. They'll be advised of the right to have an attorney, and the court will provide one for you if you can't afford one. They'll be advised of as I said, the charges and the possible penalties. And then in addition to that, there will be a discussion about bond. Bond is the same thing as pretrial release. The purposes of bond are to ensure that the person's going to show up for court, to protect the community, to protect the alleged victim. And, basically, when assessing that, the dangerousness to the community factor, it becomes relevant if the person is employed or unemployed. Or do they have a substance abuse problem? Do they have an alcohol problem? Have they been in their relationship at issue for 35 years? Have they been in it for 12 days? Do they have a child in common? Is there a pending custody case or divorce case? All of these different factors come into play when a judge is setting bond. Have they retained an attorney? Usually people who retain attorneys don't state when they're charged with a crime. So there's all kinds of factors that can be discussed at that hearing. Next, at that hearing, as I said, they'll read the charges. They'll also give the defendant a piece of paper called the complaint and warrant. It's actually 2 pages, but they have pretty much the same information on them that say what the charge is. After the hearing, they'll receive a court order with their conditions of pretrial release. And in addition to no contact and no return to the scene of the crime, the home where it occurred, even if they own it, even if the person who is the alleged victim doesn't own it, not married, the person accused is the person who has to leave. There may be a condition in there that there can be contact in regards to communicating about the exchange of children if they have children in common, but all other communications, direct and indirect, will be prohibited. You can't send flowers, you can't send emails, you can't tell your buddy, go tell her this. You can't call her mom and say, go tell her that. You can't show up at her work or her employment. You can't make phone calls. You can't text. You can't email. You can't snap. You can't kick. No contact is no contact. Another provision may be random alcohol or drug testing. Another provision may be a curfew. It's really decided, as I said, on a case-by-case basis. If this person is a repeat offender, then they may be on tether, they may be on home detention, or they may be, or a bond may be set really high so that they're in jail during the pendency of their proceeding. There are several different kinds of bonds that can be set. The first type is a personal recognizance bond. That's basically, or PR bond. That means that no one has to post any money, and that if the person doesn't show up, then the money would have to be posted in order for them to get out of jail. You can have a cash bond, which is $10,000. You pay $10,000 and you get out. Or you can have a cash surety or 10% bond, which means the bond was set at $10,000 or 10%, which means that you can post $1,000 and in order to get out. If the only one of those bonds that you will get it all back if you are found not guilty, is the cash bond. It's $10,000, you post $10,000. Otherwise, the court will keep 10% as a processing fee if you're convicted. If you're convicted, they may also apply your bond money to any fines and costs or attorney's fees that have accrued during the case. If a person is while they're in the process of being arrested for domestic violence, if they take off and it forces a high-speed chase, the person can also, in some jurisdictions, they'll try to add on a cost of the police chase. That was times when the police couldn't help other people. Some courts will not do that. Other courts, prosecutors ask for it and get it. It just depends. So then the next thing that will happen is that depending if it's a misdemeanor or a felony, let's just talk about the misdemeanor. Misdemeanors stay in district court. That's your city or township or village court. And there's several jurisdictions within one district court, or it can be just one. And what happens is the next time you come to court on a misdemeanor will be a pretrial. If you haven't hired an attorney, your court-appointed attorney will hopefully have contacted you before you got there, and your court-appointed attorney will meet you there that day. As I said, hopefully they've met you or called you before that day. If you haven't already received a copy of your police report, your 911 tape, or your 911 call recording, any dash cams, if the police car video or audio was recording the encounter, or any body cams. That's the camera that's affixed to the front of a police officer's uniform that also does audio and video. So if there are any hospital records, if there has been any medical treatment, all of those things should be turned over. If they're not turned over before the pretrial, they will be turned over shortly after. Just recently, thanks to Justice Bridget McCormick and the rest of the Michigan Supreme Court, it is now mandatory that discovery be exchanged in misdemeanor cases. Several years ago, we lost that right, and really, we got it anyway. It was just more steps. It was more expensive for our clients. So now it's automatic, so that's a good thing. After the pretrial, which is basically a discussion, the discussion will be, it could be anything from the strengths and weaknesses of the case. It could be a plea offer. As we talked about a couple days ago, the plea offer, if it's a first-time offender, could be to a deferred or diversionary type of arrangement where the person is put on probation pursuant to Michigan compiled laws MCL 769.4a. if they successfully complete their probation without getting in any more trouble, they complete their treatment, whatever they're required to do, then it will be dismissed. The arrest remains on their record, but it will be dismissed. So that, if that is an option, that could be extended at the pretrial. Another thing that could happen in forms of a plea, in terms of a plea offer, or someone is accused of aggravated assault, which is domestic violence or assault and battery with an injury, not a severe injury, it's still a misdemeanor. Maybe it would be reduced to to the 93-day domestic violence misdemeanor, and would be and then you could try to get the 769.4A resolution. It is not mandatory that the plea bargains are offered in any case. In some cases, the alleged victim will absolutely not consent to any sort of plea offer. So in that scenario, there will not be one. It is in our day and age now, prosecutors do not accept offers that the complainant or alleged victim is not on board with. So we have to work a little harder. So some of the things that when we're working a little harder to mitigate or to get a good deal, we may refer our clients to a batterers program or specialized batterers counseling. For those of you who are research junkies like me, there's actually a publication in Michigan that is created by the governor's task force on batterer intervention standards in June of 1998. It's still valid in Michigan, and it talks about the standards of these programs and what they have to do. It's really an interesting document because it obviously defines what a batterer is, what a victim is, what a domestic violence is. It talks about the philosophy behind intervention for batterers in Michigan. It talks about reporting requirements if there is additional criminal behavior, about admissions, about some of the evidence. It talks about the modality and the method to be used when working with alleged batterers or admitted batterers. It talks about the program's policies, what happens for non-compliance, what happens if someone doesn't show up, what their record keeping or additional referrals for services are, and then collaboration and coordination with the community, whether that is collaboration with a probation agent, with an attorney, with the court, whatever it is. And so those types of programs range from, usually the shortest one I've ever seen was 4 weeks, and that's a pretty intensive one. Most of them are anywhere from 6 months to a year. It's a very long time. There are some in between. Some are better than others, of course, like anything. And if you're going to be in one of those programs as a mitigation to hope to get a better plea offer or a better sentence, it's really important that you're in a program that the court is familiar with or that is going to speak for itself through its results. Sometimes if we need a matter to resolve quickly, I actually have sent some of my clients to a private domestic violence batterer therapist who that's all they do all day long. They teach the classes, and then they also do this individual program. It's really easy to structure a program in individualized therapy if the person is already in it, but you have to have an evaluation that shows the person's the accused propensity or their personality traits that may make them angry or have triggers or be, I don't want to say defiant, I don't want to say irrational either, but make them act before they think, make them reactionary, make situations escalate quickly, not understanding the social cues or being able to give the social cues to resolve any sort of dispute without violence. And I'm not just talking about physical violence. So these are the types of things that happen in a batter intervention program. And as I said, they're offered by many communities. They're offered by some courts. They're offered by some shelters. The First Step program, which is a victim shelter at Haven, which is also a tremendous resource for battered women and men, offer batter intervention programs as well. And so there are resources right in the community. It is possible that if someone pleads guilty, that they will be sentenced to up to 93 days in jail. That is going to depend on who the person is. Sentencing is supposed to be individualized, and it should be individualized to fit the facts of the case and who the accused is, as well as the relationship with the complainant. Most people who do end up going to jail are on their first offense are people who are in certain courts, or people who this episode occurred in front of their children. So that is, those are really across the board. If the domestic violence incident occurs in front of children, that is going to be a factor of enhancement as you go through the process. If you don't plead guilty, then you'll go to trial, and you have a right to a jury trial, and everyone will have to participate in the trial process, meaning the lawyers and the judge, the public. There would be jury selection, and back to, I think it's in the 20s somewhere, maybe in the 30s. We did a whole session on about jury duty and what it's like to serve, what voir dire is, why they ask you all these questions, what it's like to deliberate. And so with all those things in mind, you can go back to that live if you are interested. But what happens is they basically, you impanel a jury. The prosecutor will go first and give their opening statement, which is kind of the framework of their case. They always call it a roadmap. We kind of, as defense lawyers, laugh when they call it a roadmap, only because they all say it, and that's what they learned when they were trained. I like to think of opening statement more as a framework for the jury to put the evidence in its little squares and circles, and then determine what the facts really are and how they fit together or don't. Recently, I had a domestic violence case where my client and his 15-year-old daughter got in an argument. He asked her for her phone to ground her. She wouldn't give it up. They were yelling at each other. It was not physical at all at that point. They came down from her bedroom, down the stairs into the foyer, sort of open common area in their home. And mom called the police and said there's a domestic dispute because the daughter and the dad were arguing. And then as she's on the phone and the 911 operator is asking her, is anybody hurt? Is this happening? Is this happening? She says about, probably 4 minutes into the 911 call, he hit me. At the same time, she doesn't know this is happening. Her other daughter has called 911. And her other daughter is literally saying, my mom just said this happened and that isn't what happened. My mom isn't telling the truth. My dad isn't even in the same room and she's saying that he hit her. And so needless to say, we had to try the case, and it was a one-day jury trial, and he was found not guilty, and they're getting divorced right now. So trials can happen for many, many, many different reasons. Sometimes because we don't have another option. Sometimes because the allegation isn't true, or it's exaggerated, or fabricated, or misunderstood. Sometimes we have lots of evidence, and sometimes we just have he said, she said. So really every one of these cases looks different from a fact and prosecution standpoint. If someone is found not guilty after a trial, then the charges are dismissed and they go on with their life. Hopefully they don't put themselves in a situation where they could be accused or falsely accused again. And if they are found guilty by the jury, then they will be sentenced. And they'll be sentenced, most of the time to a period of probation with conditions. And those conditions, as I said, would include a therapy component, better intervention, as well as a punishment component, which could be jail time, it could just be monitoring. It just depends on the facts. If someone is convicted of domestic violence and have no other offenses on their record, after 5 years, they can go back into court and ask for it to be expunged from their criminal record. So they can get rid of it, but they have to, there are very strict criteria for expungement. And so, and those rules all changed about a year ago. So there are exceptions where if you, actually I think they have to be priors, not post. So there are some nuances to that to qualify for expungement. But if this is your only offense and you don't have any more, then you would definitely qualify for expungement 5 years later. So that is pretty much what a misdemeanor domestic violence case looks like if it's going through the legal system. If it's been enhanced because it's a third offense, or if the charges are other assaultive crimes such as felonious assault, assault GBH, great bodily harm, less than murder, assault with intent to murder, if it's any of the child abuse offenses. I'm trying to think what else we talked about yesterday. Parental kidnapping would go through the system exactly the same way as the domestic violence did. And so with the felonies, though, you would have a right to a preliminary examination, which is a probable cause hearing. It's a very low standard of proof at that stage of the hearing, where the complainant or the accuser would testify, and the district court judge would have to make a finding of whether or not there was probable cause, which means probably plus a little more, that a crime was committed, and probable cause that the person accused committed the crime. And if that happens, then the case it's bound over if there's a probable cause finding, and then it goes to circuit court. When it gets to circuit court, the person is arraigned again, and then they go through the process in circuit court that can go in several directions, but the next hearing would be a pretrial, where again they could decide if they want to plea, they could decide if they want to set it for trial. If there's evidentiary issues, they would have motion hearings, and that could be challenged. If there's discovery issues where they haven't received some medical records or the 911 tape or whatever is out there in any particular case, then that may be some motion hearings might be necessary. then if the person doesn't resolve the case with a plea, then they're going to go to trial. And again, with a jury, same procedure as in district court. And that then if there would have to be a unanimous verdict. And then if they were found guilty at that point, it would go to sentencing. If they were found not guilty, then it would be dismissed. So that is basically the procedure and the pathway if someone is accused, arrested, or charged with domestic violence or any of the other crimes that we talked about yesterday and the day before, as possible crimes that can be charged when someone says they were abused. The last thing that I wanted to talk about today is the stages of recovery after trauma. And this is basically the cycle of healing that is looked at in terms of the therapy or the intervention that the accuser or complainant or the victim is going to go through. And it's really interesting because its roots are in science, but it's the journey of what got people there, the different feelings they had about why they couldn't leave, why they couldn't get help, why they couldn't fix their relationship, the feelings of guilt, of disappointment, of self-failure. It goes through all of that. So phase 1 is the safety and stabilization phase, and that's when trauma survivors feel unsafe in their own bodies or in any relationship with other people. They have trouble regulating their everyday emotions. They can cry like out of nowhere, and really it's like the point in time when they don't feel safe no matter what the circumstances are, and their goal is to regain that feeling of safety. And phase 2 is remembrance and mourning, and that's when survivors begin to process their trauma and assign words to the emotions that they felt at different times along the way. They try to find meaning in it, and they try to, and that usually happens in therapy because obviously the person has to go back and relive in their head or out loud what they have been through. Phase 3 is the reconnection and integration phase, and that's when survivors recognize the impact of the victimization they experienced, and they begin to believe that the trauma is no longer the defining principle in their life. And that is, that's when a lot of people look at their life as having a new future. A lot of people go to they get jobs or they go to school to learn more about trauma and helping other people, advocating for the survival, and that is that's where a lot of people find their coping mechanisms. Many people are emotionally beaten down. They're tired. They don't want to work these steps. They're not ready to work these steps. It can take a very, very long time, and it can have a lifelong impact. It certainly can skew the way that you look at the world. I think it would be very hard if you were a victim of severe abuse in any manner to really be able to embrace the presumption of innocence. And so, I just wanted to touch on that. I didn't want to just talk about the accused out of respect for those who actually and really are abused or are harmed by people who love them. There's lots and lots of books out there, lots and lots of resources out there. One book that I would recommend is called find help for domestic violence faster and easier. And it's that's at domesticshelters.org. And like I said, the governor's task force, as well as the Domestic Violence Prevention and Treatment Board in Michigan, have a ton of resources for both people who have been battered or people who do batter, to make this a better society and a better, safer place for everyone. So with that, I will conclude our 5-part series on domestic violence. I do have a couple, please, can you do me a favors? As I mentioned a couple episodes ago, we are really trying to get 100 likes and subscribers on the Kirsch Daskas YouTube channel. We can't get our own URL until we hit 100, and we are so close. So if you have really nothing to do, or your kids have nothing to do, please go on YouTube and subscribe to the Kirsch Daskas channel, and you're really helping us out. It also really helps us out. We're trying to get 1,000 likes on our Facebook page. So if you wouldn't mind right now, while you're on it, if you could just click like or check in, both of those things help bring people to our page and to our website. And so that really helps us. Also, I will just give you a little what's coming. Where the next 5-part series is going to be about divorce and untying the knot. And so we're going to start with that on Monday, actually. Tomorrow I'm going to talk about personal protection orders, how to do them if you need one, what the best way is to have it granted, what happens if you file one and it isn't granted, all different things like that. So we'll talk about that tomorrow, as well as the different items that you need in your wheelhouse to successfully get a personal protection order against another person, or if you are the person who they're trying to protect themselves from, how we defend those as well. So all of that will be tomorrow. And I think I'm 90% sure we're going live at 1 o'clock at our usual time tomorrow. But if not, it'll be posted what time we're going as an alternative. So with that, 5 reasons not to harm your loved ones during quarantine. Protective services workers are essential. The police are essential. Our jails and prisons are still hotbeds of COVID-19. Parents can get in trouble for kids being kids is number 4. And number 5, very few people, if anyone, look good in horizontal stripes. So with that, I will wish you all a wonderful, wonderful day. Stay home, stay healthy, find your happy, and I will talk to you tomorrow. Bye.